we were just hearing testimony from Kevin Dredden from yesterday. He's a coworker of one of the victims, Xenia Suarez. He was telling the court about how the day before Suarez and her 2 children went missing, believed to have been murdered by Toledo, Toledo himself showed up at their office, caused a scene, confronted Dredden about the affair, which he denied at the time, likely out of fear of what Toledo might have done. So, you have the defense yesterday, at the end of the day, arguing before the judge that the prosecution has proven that a death took place, but not a murder. Now, here you have a motive being established by the supposed lover of one of the victims, showing that Toledo was upset about an affair that he suspected was going on. We already heard from expert witnesses talking about blood that was recovered that matched the children. And then, of course, you have the fact that none of the bodies have been recovered. So you have a motive, you have DNA evidence, and you have 3 people who have vanished with evidence that there was a bloody demise. People don't just die and vanish. So it definitely looks like a murder. I'm here with attorney Jonna Spillbor. Jonna, if you're the defense in this case, how do you come back from this?
Oh, man. You really have an uphill battle if you're defending this guy in this case. And it is really hard. And I think part of the evidence that the lover of the, we're assuming deceased and assuming murdered person is trying to establish is the motive. Because we're going to have a couple of, I mentioned dots earlier, we're going to have a couple of dots to connect here. And one of the things that the jury is going to have to contend with is if the jilted husband of a cheating spouse did not cause that person's death, then who else did, right? Because as you mentioned, a healthy 28-year-old woman and 2 healthy, beautiful, innocent children don't just die of natural causes, right? So even if you're going to try to argue as the defense attorney that you've proven a death, but you haven't proven the manner of that death, it's a very weak argument. Now that said, as a former prosecutor, you probably know, because you've been across the table from defense attorneys like me, sometimes we are compelled legally to put up every argument that we can to preserve the defendant's rights should the case eventually get appealed or what have you. It's our job. So even the weak arguments need to be presented because they're, as long as they're valid arguments. This one's a really weak argument.
Yeah. It remains to be seen, what's going to happen later in this trial, if the defense has any tricks up their sleeves. The prosecution is still presenting their case. More could come out. Sometimes we see cases where the defense is poking holes in the prosecution's case while the prosecution is still calling witnesses. We're not really seeing much of that right now, at least not yet. But when the defense starts calling their witnesses, who knows what we'll hear, but it's not looking good for them right now.
Plus, I don't know if you hearken back to, there was a case a long time ago, Danielle Van Dam, Westerfield, David Westerfield was arrested and charged with the murder of a young girl, Danielle Van Dam, before they found a body. And then lo and behold, after he was charged and everything got started, they did find the body. You don't know, we don't know if they're ever going to find these bodies, but they very well could. And listen, we can't prejudge anything, but I seriously doubt this jury is going to acquit this man on murder charges. They might spare his life, but they're not going to acquit him. Because can you imagine what would happen if you did? You're on trial for murder, bodies aren't found, you get acquitted, bodies are found, they can't retry you. Now that would be a travesty, wouldn't it?
Absolutely. And he's facing the death penalty right now. That could be his only saving grace, that maybe this will, not having the bodies and not having 100% certainty could spare his life and just leave him with life in prison without parole. But there's a lot of evidence against him. Right now.
Yeah,
so
circumstantial,
it's not,
but it's still evidence.
But there's a lot of it, and there's a motive. There's DNA evidence. There's so far not much of a strong opposing theory of the case. So we'll see what happens, but he could end up going away for a long time, if not facing the death penalty.
I'm curious if there were any plea negotiations on the table, like you plead guilty, tell us where the bodies are, and we'll take the death penalty off the table. I would be surprised if that did not happen.
Yeah. I don't know what kind of negotiations may or may not have taken place between the defense and the prosecution.
Yeah, we never do.
But even discussions that they've had about other issues in this case apparently haven't been going well. As we saw earlier this morning, and the reason why we're on this long recess right now in the middle of the morning is that the prosecution was all set to play a recording of the interview between Sergeant Pagliari and Toledo. They started showing it to the jury for a few minutes, and then they stopped. There was a sidebar. There was an objection from the defense, and it turns out there were issues regarding which portions were supposed to be shown to the jury, which portions were supposed to be redacted. Apparently there were certain lines, certain language that the sides didn't want or had agreed to not have the jury hear, and the prosecutor told the judge that he and the defense counsel had met, I believe yesterday, went over all of the audio as well as transcripts, and went line by line to decide what they were going to play, what they weren't going to play, and yet once the footage started rolling, it wasn't what was expected. So they had to have a sudden halt to the recording being played. Now they're on this long recess to kind of sort this whole thing out. And hopefully we'll be able to get you back to that trial soon, and maybe we'll be able to see more of this interview. In the meantime, we just showed you some of the testimony from Kevin Dredden, who was the co-worker and supposed lover of the deceased Yesenia Suarez, Luis Toledo's wife. We're going to show you some more of that testimony right now.
Did you receive another call from the defendant around 2:10 later that afternoon on October 22nd, 2013?
I did.
Okay. And did that call come from the defendant?
It did.
So he initiated the call?
Yes.
Okay. Again, if you tell us, please, what was said during the course of this conversation with the defendant?
Well, he was saying, don't involve the police. He wants to keep it between Yesenia, him, myself, and my wife.
During the course of this conversation, did he say that he wanted to meet you in person?
He did.
Okay. And did you think that that was a good idea?
No.
Why not?
I mean, I saw what just happened. I know it was, I was in lie at that time. It just wouldn't be a smart thing to do.
Okay. Late in the evening on October 22nd, 2013, did you receive some strange text messages from the phone of Yesenia Suarez? And when I say strange, different than her normal pattern of speech, different than her normal spelling, different than her normal punctuation?
I did.
Okay. Did those text messages come in about 6 minutes to midnight on October 22nd, 2013? If you remember?
I believe so.
Okay. Would you like to look at the phone records again?
I could.
Would it help?
Just to, yeah. Yes, correct. Mm-hmm.
So about 6 minutes to midnight, you received a text message from Yesenia Suarez's phone. Is that correct?
Correct.
Okay. During this text message, did she ask you to speak with her?
She asked me to, yes, speak with me.
Did she make a mistake, or whomever was holding her device, did they make a mistake about your wife's name in that text message?
That's correct.
Is that the text message where it said, I think we should tell Shelley everything?
That's correct.
But your wife's not named Shelley, right?
No.
Okay. After you received a series of about 3 text messages there, did you begin to place calls to Yesenia Suarez?
I did.
Okay. Did you call her about 11 times or so in the next 23 minutes?
Yes.
Okay.
Yes.
Did you ever receive a response during those calls?
No.
Okay. Did you follow up with a text message about Pete Owen?
Yeah, I did.
Okay. What's the significance of calling, what did you say, first what did you say about Pete Owen?
Well, I said, if you don't pick up, I'm going to have to call Pete.
What's the significance of calling Pete? Who was Pete to all of you guys?
He was our supervisor.
But he was a little bit more than that, though,
And
right?
he was a leader. He was one that people confided in at work. And I knew if I mentioned his name, if she was receiving the call, then maybe that would likely get her to return the call.
And then did, in fact, you get another message from her a short while later? Or a message from that phone?
I had to look at it again.
Sure, no problem. I know it's a lot to remember. Okay. Having reviewed the document, is your recollection now refreshed as to the course of communication that evening?
Yes.
Okay. After this message that you sent, in which you named Pete, did you receive a response from her about 20 minutes later?
I did.
Okay. Having gotten that response, were you satisfied that everything was okay in her world?
No.
Okay. What did you do to make sure that she was all right?
What did I do to make sure she was all right?
Yeah.
When I felt concerned?
Yeah.
Yeah. I'm not sure when, but I did call my boss. Yeah.
And did you talk with Jessinia Suarez around 12:49 a.m. on October the 22nd, or excuse me, on October 23rd, in the early morning hours around 12:49?
Yes.
Okay. Do you have a recollection of how long that conversation lasted?
Not for sure. I know the phone records will say what it was.
Yeah, the phone records say 14 minutes and 13 seconds. Does that
sounds-
seem about right?
That sounds right.
Okay. Now, again, you can't tell us what she said, but I want to talk with you about the general tone and tenor of the conversation. Try and give us a sense of the conversation, would you?
She wasn't herself.
In what way?
How she was speaking.
Give us some idea of how she was speaking, that it was different.
It sounded like maybe it would be coming from someone that was drugged.
What made you,
I'm sorry.
what,
That's total speculation.
if I could clarify?
Yeah.
Strike that answer, that's not right.
Well,
If I could clarify,
okay,
there's no allegation
I'll
that she was
sustain
drugged.
the objection. Rephrase the question.
Yes. Mr. Dredden, was Jessinia Suarez's speech slurred that evening?
It was.
Okay. Did she seem to have some pressure on the way that she was speaking?
Objection, Your Honor. She have some pressure, is speculation limiting me. The question is vague and speculative.
Can I ask a different question?
Go ahead and ask the question.
Was the conversation forced? Was it a difficult conversation?
It was.
Okay. How did she seem to you? Was she happy? Was she upset? Was she sad?
She didn't seem, well, she wasn't happy. She was very soft in her words and very severely slurred in her speech. She seemed to think that she has a plan on, on being there because I was concerned with the safety. She said no.
Did she seem to want to stay in her home that evening?
Yes,
Were you concerned for her safety staying there?
I was. I was law enforcement, and the first thing they tell you to do is separate for any domestic violence.
Okay.
And I told her to think about the kids.
Objection, Your Honor. This is not responsive to the question. His experience is irrelevant.
Sustain.
Did she ever tell you whether or not the defendant was there with her?
She did.
Okay. Did she say that the defendant was in fact there?
Well, she told me that he was sending the text earlier.
Objection, Your Honor, hearsay.
Sustained.
Move to strike the answer, please.
The jury will disregard the last answer.
Did you get a sense of whether or not the defendant was there with her at the time of the call?
Yes,
Okay. Was he there with her during the time of the call?
I believe
Objection,
so.
Your Honor. Did you get a sense of speculative?
Judge, I can't ask for the direct quote because it's hearsay, but he can talk about the generality of the conversation and whether or not he learned during that conversation that the person was there. That's not hearsay.
Sustained.
When the call ended at 1:03 a.m., was that the last contact that you ever had with Jessenia Suarez?
It was that I know of, yes.
Right. It was the last time you heard her voice for sure, right?
Correct.
How did she seem when the call ended? Was her demeanor the same throughout?
It was consistent, yes.
The following morning at 7:02, did you receive a text message from her device?
I did.
Okay. Do you have any idea whether or not she sent it?
No idea if she sent it. Okay.
Within a couple hours of receiving that text message, did the police come to your house?
Yes.
Did they seem to want to talk about Jessenia and whether you had seen her?
Yes.
Did they seem to know anything about the affair that had occurred at that point?
No, they just asked, well, I don't know if they seem to know about the affair or not.
Did you talk with them about the affair?
I did.
Okay. Had you even admitted it to your wife at that point?
No.
I only have one more question. As far as you can tell us for certain, your last contact with Jessenia Suarez ever was 1:03 a.m. when that call terminated. Is that correct?
Correct.
Thank you.
And welcome back, everybody, to the Law News Network. I've taken the host chair from Ron. Rachel Stockman here, also editor-in-chief of LawNewz.com. Thanks so much for joining us. We are on standby mode for the Lewis Toledo trial, which is supposed to start any minute now. As soon as we get word that court is alive, we will take you there. Attorneys were having a bit of a debate about what portion of the Lewis Toledo interview tape with police that they would show, which is a bit unusual. I'm joined by criminal defense attorney Jonna Spillbor, who's been with us all morning.
Yep.
Very unusual that they're not showing the whole tape for the jurors.
Oh, absolutely. I mean, normally it either all gets in or none of it gets in, but 9 times out of 10, it all gets in. And 9 times out of 10, it's usually not good for the defendant when their police interrogation gets into evidence. It was odd here, though, Rachel, because the counsels talked about prior to showing this to the jury, they went through it line by line, page by page, had special trial instructions read to the jury because they were about to hear this evidence and look at the transcripts. And then 11 pages in, stopped the presses, and we're not even quite sure why. There was no revelation during that portion of the interview that was earth-shattering. It seemed to be pretty innocuous, yet now the jury's on a break while the defense counsels go through it again, line by line, page by page.
And very unusual because most of the times in trials we've seen and covered, when they have an interview tape, the defense either, of course the defense doesn't want it in, but if they have to have it in, they want the entire tape because they want the jurors to see the entire context of what happened. Okay, so Jonna and I were having a big debate while we were listening to that soundbite from earlier testimony. And this has to do with one witness that took the stand earlier this week. He took the stand on Monday. Tyshawn Jackson is his name. He is a key witness for the prosecution. Yeah. And he claims, there he is on your screen right there, he claims that the defendant, Toledo, went to him after this alleged murder happened and drove around in the car, saw him cleaning the car, dump a bunch of stuff in a dumpster, and then he claims the defendant said, "I snapped" to him.
Yep.
You don't buy this guy. You think he's lying.
I don't buy a single word. Maybe perhaps the defendant did say to him, "I snapped," But let's break this down, shall we? It makes no sense. Be a murderer for a minute. You pick up your neighbor just to what? Have a companion to change the radio station while you're driving to get rid of evidence?
That's what I never got about this guy. It's
Doesn't happen that way.
After you murder someone, why are you going to go to your neighbor's house and be like, hey, want to help remove the evidence from my car?
Exactly. Like, there'd have to be more involvement by this neighbor, number one. And number two, be the neighbor. So, if I come pick you up, I just committed a murder and you're in my car and I say to you, I snapped, you're just going to sit there quietly and not ask me any questions? You know that wouldn't. It's not human nature.
I'd say, whoa, whoa, whoa. You want me to be involved in this, man?
Yeah.
No.
Let
I'm
me
done.
out.
I want out of this.
So
that's what a normal person would have said, I think.
It seems this witness, the prosecution wants this witness because they want to get in evidence that of the admission that the defendant snapped. But the rest of his testimony is so unbelievable that a jury will likely be instructed they don't have to believe a single word that came out of it. If you think a witness is testifying falsely as to one thing, you can discount everything that witness says. So I don't think this is a smoking gun witness for the prosecution at all.
And our senior trial producer just wanted me to clarify that Toledo drove his wife's car and the neighbor was asked to follow him in Toledo's car.
Right.
And that's fine, and say they were buddies. We know they were friends from, they went to they had gone to barber school together, and that's fine. I get they're friends.
Yeah.
But at the same time, why do you get someone else involved to help you?
At 5
and why does
o'clock
that
in the
person
morning.
agree to it without asking more questions?
Exactly. And now this person is compelled to testify as to the damaging thing that the defendant allegedly said. But like I said, for the prosecution, he's not a star witness because the rest of what he's talking about just doesn't add up for a normal person.
And some of our trial watchers that are watching right now are saying, well, he didn't know at the time he was helping him. He just thought he was helping move one of the cars.
With blood on it? Because there was a blood cleanup. He goes to a dumpster. Why does he have to move his wife's car at 5:30 in the morning or whenever it was? It was very early in the morning. And he even said he never came to my house that early ever before. He knew something was up, and he either knew because he was involved, he knew because he asked, and he's not being truthful about that on the stand, guaranteed.
Well, some people believed his testimony and thought, well, this guy's a friend, and he was just asking a friend to help him out. This guy had known him for a while. He had no idea what was going on. But the circumstances are strange, and it would lead me to believe he asked more questions than he's revealing.
Yeah, and he knows more. He knew more then, and he even knows more than he did when he testified. But I think the crucial piece of evidence that the prosecution wanted was the testimony that I snapped. That's what they want to get from this guy. They got it, just don't know if the jury's going to buy it.
Is going to buy the whole thing.
Right.
Because again, at first when he approached him, he didn't tell him what they were doing. But again, the situation's sketchy. At 5 in the morning, why are you doing this? Why are you getting rid of a car? I mean, the whole thing.
And the average person, take it out of the murder context for a second. If somebody stops you on the street of Manhattan and says, hey, come here, I have a Jimmy Choo bag for sale for $25 and it's genuine, you're going to know something's up, right? You can't be willfully ignorant of that. So I guess maybe
well,
the witness
he
is
did
trying
know.
to
You
say.
could tell he kind of knew something was up, even to what he admitted to, because he said, I wouldn't ask any more. He said, I didn't want to ask any more questions. I didn't want to know. He said that on the stand.
And that's another thing. If you don't want to know, so you don't want to know because you suspect there is some sort of criminal activity afoot, but you're still helping out. You're driving the car. You're with the person. Again, either get out of that situation so that you have some credibility, or, like I said, I am not buying this story, hook, line, and sinker.
Well, I'm sure the investigators threatened him with charges as an accomplice if he didn't give everything he knew.
Accomplice after the fact, at the very least. Yep.
So he felt a lot of pressure to testify because I'm sure he was scared of possible criminal charges because of his involvement.
And let's not forget, the defendant apparently has a history as a gang member. So, he has every right to be afraid of that as well.
Well, very good. We've been talking a lot about this witness, Mr. Jackson. He took the stand on Monday. If you're just joining us, I want to play some of his testimony, and I was going to do that for you, but I'm looking in the side of my screen here, and it looks like trial has resumed in Toledo. And I think we'll be able to hear his interview tape with police. Yep, so let's can we take a live shot of the courtroom so folks can get a chance to see what's going on with that? Yeah, there you go. Okay, so we see a door right there, but it's going to zoom out in a few seconds, and it looks like all the attorneys from both sides, the prosecution and the defense team, as well as Toledo, are back in the courtroom. Could you tell us, Jonna, just fill us in what happened earlier? They were having a debate over this tape.
All right, so the prosecution wants to bring in the actual tape of one of the interrogations of the defendant. The defendant was in custody on some other charge. This interrogation was specifically a, quote, missing persons interrogation, not a murder interrogation. And the interrogating officer established at the very beginning that, hey, you don't have to talk to me. This is going to be a voluntary conversation. If you want to have it, you are free to leave, although he really wasn't free to leave because he's in a jail. But set that aside for a minute.
He was on domestic DV charges,
yes.
domestic violence charges,
yes.
for the incident that happened the previous day where he confronted his wife and
exactly.
her lover at work.
Separate and apart from the, quote, missing person case. The officer's tenor was, listen, I need your help in finding your wife and her children. So please, whatever information you can offer up, please help me, which is obviously a tactical ruse because I'm sure they suspected foul play at that point. The two sides, the prosecution and the defense, had previously gone through this taped interrogation, created a transcript from it, redacted portions of both, and then rolled the tape.
And John, I don't want to cut you off, but it looks like we're back in live